Hello, I am Nina Hunter. I will be your guest facilitator for today in your Health Law Ethics course. I want to thank your facilitator, Dr. Leah Raby, for having me. I am a licensed practicing attorney. I've been practicing law here in the state of Louisiana for almost 15 years. And I am going to be talking about the law, courts, and contracts. We're going to start by first talking about sources of law. In the federal government, of course, the government is broken into three parts. You have the legislative branch, the executive branch, and the judicial branch. The legislative branch is what you are hearing a lot of about today, currently in the news. It's Congress, right? Congress is made up of the Senate and the House of Representatives, where they both have the ability to draft legislation or laws that can, if they are approved in both houses, become law for the entire country. A perfect example of this would be, what's going on with the coronavirus right now in legislation that the federal government is attempting to pass in order to provide relief to Americans during this pandemic. The executive branch, of course, you can relate to, again, is, of course, our president currently now. Can't think of his name. Donald Trump. Very active, very much being in the news lately. He has the ability to sign executive orders. Executive orders don't have to go before Congress, and that entitles him he has a certain type of executive power or administrative power to do things from his desk as the President of the United States. And of course, the judicial branch is represented by the Supreme Court, which interprets and oversees the laws of the state. Examples of Supreme Court justices include, I can't think of any right now. I know we have some that most recently have been appointed by President Trump, but I can't think of any right now. They're coming immediately to mind. State government is broken up in the same way. You have the legislative branch, the executive branch, and the judicial branch. All three branches operate pretty much in the same way. In Louisiana, for instance, the legislative branch is made up of the House of Representatives and the Senate the same way it's set up at the federal level. You also have the executive branch, which is led by the governor, of course, the governor of the state of Louisiana, John Bel Edwards. And then you also have the judicial branch. In Louisiana, the highest court being the Louisiana Supreme Court, which is also broken down into First Circuit courts and then district courts. If we were in Louisiana, then of course that would be the Louisiana Supreme Court, then the circuit courts, and then the district courts. In East Baton Rouge Parish, for example, that would be the 19th JDC. Okay, so now that you have the breakdown of the different, of how the system, our governmental system is basically set up, all under the judicial branch, whether you're dealing with Fed or state, then it's important to know the 5 types of law. Of course, the United States has the U.S. Constitution, which is the bedrock or the foundation of our legal system. Just as the federal government has a constitution, states also have their constitutions, which also, again, are the bedrock or the things, the laws that are the foundation, the laws that can't be changed or the laws that are really hard to change. You won't be able to change unless a really huge, what's an example, a huge push by the entire community. You have to have a majority vote almost in order to change the Constitution. And so in most instances you won't see that happening. But all states have a Constitution as well. But case law is a strong area of the law which is created in the judicial system. So when a case is litigated or you go before a judge, in most instances, there will be a ruling and an opinion attached to that ruling, and that opinion can be used as precedent in other legal cases. For example, if I wanted to sue my landlord for evicting me out of, or trying to evict me from my home, but I didn't want to leave my home because, I didn't pay my rent because there were some certain things that he needed to do, like fix things, major repair to the home that he had not made. And so I didn't pay my rent, but he said, you know what, so what? I'm evicting you. If I decided to sue him, or in order to fight the lawsuit that he filed against me in court, I could use precedent or facts from another case where a similar factual situation occurred, and that could help me win my case. Or I could use that case as authority to tell the judge, hey, you should rule in the same way they did in this case because the facts are similar, the law is similar, and they're both applicable to what's going on in this case. And so Louisiana uses legal precedent, and so do other states as well. So along with case law, which is law that is created through the judicial court through trying cases, you also have what's enacted by the legislature, right? The legislature on the federal level and the legislature on the state level, and that includes statutes, right? Laws that are put on the books. The same way administratively, the governor of our state, Louisiana, has the ability to create rules and regulations that are going to be called administrative laws. And the federal government has the ability to do that as well. So those are all the different types of law that we use in the United States. Classifications of law. Law can either be substantive law, which means it's speaking to the actual situation, it's speaking to actual facts, it's applying specific legal principles, or you can have procedural law, which kind of just deals with processes. Of course, there are criminal laws, which deal with crimes in Louisiana. All of the specific crimes, things that are illegal in Louisiana, are listed in codes or statutes. Or you can have civil matters, which are tried. Well, the best way to distinguish between criminal and civil is criminal results in or could result in jail time, or it could result in the payment or a fine or a fee. If the matter is tried civilly, it's only going to result with a monetary result. Types of criminal law, just to break that down, felony offenses are punishable by death or imprisonment for more than 1 year, or misdemeanors, which may be a fine or imprisonment for less than a year. Tort liability, we're kind of getting a little bit closer to the healthcare field here. Tort is where it's a civil matter, so it's not a criminal matter, it's a civil matter, where you breach a duty. There was something you were supposed to do, you had a duty to do it, but you did not do it, and as a result, someone was harmed by it. And that's essentially what happens in the tort world, and once that harm occurs, you can be held liable, which means you can be responsible for paying money damages. Different examples of torts, things that you've heard about: assault, battery, that's hitting someone or making someone feel fearful that you're about to hurt them. You've heard on the news in the celebrity world, defamation, which means telling something that's untrue about someone and it affecting their ability to make money or do things. Fraud kind of speaks for itself: intentional infliction of emotional distress. That occurs when you do something intentional to cause a person to be emotionally triggered. Also, invasion of privacy, nuisance, trespass, things of that nature. Intentional torts. Unintentional torts, which we'll spend a lot of time and really comes into play in the medical field, is negligence, right? And negligence comes into play when there was a standard of care or a duty of care and that was breached, which means, hey, you should have known better, you knew or should have known that you needed to do A, B, or C, or D. You didn't do that, and as a result, someone was injured, and now you're going to be liable for money. In this realm, in the medical, in the healthcare field, of course, that's where you get into the world of medical malpractice. And there are a few ways that medical malpractice can be proven in court. Expert testimony, which is usually a doctor or a physician, someone who's been practicing in the area, someone who's an expert in the area. Of course, there are always going to be applicable state laws and federal laws that govern healthcare treatment. The hospital may have its own policies and bylaws, which are also going to be applicable because they set the standards of care or the duty of care. A lot of times there are accreditation standards and then just what's happening in the community. So all of those different policies and procedures can set that standard of care or duty of care that can cause, can put you in a situation if you violate it, where you can be sued for damages. So as these cases come into the court system, jurisdiction comes into play, and that just means, you know, every case can't be brought in every court. There are certain grounds that have to be met in order for you to enter that court or for that court to rule on your certain situation, and that principle is called jurisdiction. And so before a case can be tried in any court, the court has to determine whether the person has jurisdiction to be there or not. Walking in the door, you've heard these terms before: plaintiff and defendant. The plaintiff is the person that's bringing the charges. The defendant is the person who is being sued or whom the charges are being brought against. We're going to shift a little bit to contracts when talking about what a contract is and the different parts of a contract. A contract is a voluntary agreement between two parties where specific promises are made, and it's made for consideration. So of course there has to be parties with at least two people, which means bilateral contracts. So starting with at least two. There has to be an agreement or a meeting of the minds, which means, hey, this is something we both want to happen. We're both proceeding to make that happen, and consideration has to be involved. Now that sounds a little weird, but that basically means money, the promise of something of value. A legal subject matter, and the reason they put the word legal there is because you can't enter into a contract to do something illegal, okay? Which means I can't get into a contract or pay someone to kill someone, and then they don't do it, and then I sue them because they violated the contract. Well, no, the court's not going to uphold a contract for you to do something that's illegal. So it has to have a legal subject matter. You also have to have what's called contractual capacity, which means you have to have legal capacity. In the U.S., a child or a person that's a minor does not have legal or contractual capacity because they can't act on themselves. So if you say, hey, I want to sue this 16-year-old because they promised me A, B, C, and D, the court's not going to enforce that because they didn't have the legal capacity to enter into that agreement. All right? And so the reason that's applicable now, getting back to the health field, is, of course, contracts are entered into between physicians and patients. You know, when they come into the door, there's an expectation that the service is going to be provided. Healthcare services are going to be provided to that patient in exchange for consideration, which is paid through insurance and through private pay. In most instances, of course, that legal subject matter is going to be the healthcare services that are going to be needed, and then the capacity, which is going to be that adult or for that parent or that adult entering into that agreement. Physicians have certain rights. These rights are relevant because oftentimes people think they can dictate what the doctor can do or don't do, but the physicians, as private professionals, have the ability to set limitations. They set their hours, they set the areas that they practice, which means you can't bounce into someone's office and expect them to work on you when they say they only handle this certain area. The same thing goes for patients. Patients have rights as well, and the federal government has found the need to kind of intervene in this area to make sure services are being rendered and services are being paid for and things are working out the way they should. So there are certain expectations like confidentiality, which is very important, which is governed by the federal law. Everyone has heard the word HIPAA used, which covers, of course, the confidentiality of information that's given to doctors. Doctors have privilege for a certain type of information that's given to them, where they don't have to disclose that information. Medical professionals will ask for permission to disclose your information to another party if necessary, and that happens all the time. It's necessary that medical information is shared, but you're going to be a part of that process, which means you're going to have to sign some type of informed consent in order for that to actually occur. Another thing that happens in the world of healthcare, of course, is implied duties of the patient. You can't just go to receive medical services and then say, hey, you didn't do this, so you breached that standard of care, you breached a duty, or you breached our contract, right? So I can sue you. Well, there are certain things that you have to do as the patient. You have to pay your fees. You have to follow the instructions of the physicians. You have to provide relevant information to your physician. Oftentimes you may have a situation where a patient wants to sue a doctor because they did A, B, C, and D, but you didn't tell them about E, F, and G, which would have impacted A, B, C, and D. And because you didn't tell them that, then you can't hold them liable. So there are duties for all of the parties involved in the healthcare realm. That is my last slide. So that's basically the main thing that we want to cover with the healthcare world, with just contracts. So just like in general contracts, they affect the healthcare arena as well. They require the same types of responsibility, the same duty of care, standard of care, which is the expectation of what you're supposed to do in order to provide services. Certain things, list of things, A, B, C, and D should be provided to each patient in order for a certain result to happen. And so in all of those instances, you can see how contracts in the legal field and the government does affect healthcare and how those services are provided. That's all we have for today. Thanks again for having me. Again, my name is Nina Hunter, and it was a pleasure being your facilitator today. I hope that you were able to get something from the lesson. Thanks.